And then the judges have agreed to do questions and answers discussion with all of you. Let me introduce them. It's really a distinct pleasure to introduce our two judges. I'll start with Judge Chin, who has been serving on the Second Circuit Court of Appeals here in New York for almost 4 years now. 4 years. And prior to that, was a judge on the Southern District, the trial court here in New York. He is a graduate of Princeton. I know I'm supposed to say that. More importantly, he's a graduate of Fordham Law School as well. And has been involved in so many of the most important technology cases of late. Some of you may have heard of the Google Books case that is Judge Chin's case. The Aereo case that's going up to the Supreme Court next month, going for oral argument next month, was a case that he also sat on. Judge Chin was also the first Asian American appointed to as a U.S. District Judge outside of the Ninth Circuit. And then to his left is Judge Marilyn Patel, a recently retired federal judge who presided over the U.S. District Court for the Northern District of California. So that's the federal court that had a plethora of intellectual property cases ranging from patents, copyright, trademark, trade secret. Perhaps her most famous case in this field was the Napster decision that Judge Patel wrote. And she, too, is a graduate of Fordham Law School, I'm happy to say. And she was, I believe, the first woman appointed to the Northern District bench at the time. So we have two really pioneering judges in so many ways, starting us off with some reflections on the day. Do you want to start with just a comment or two, and then I have a few thoughts of things we might want to chat about? Marilyn, do you want to?
Well, I was here for the whole day, and it was a pleasure. I have to say there was a lot more that I now have learned I didn't know, and so I've learned a lot through the process. And as a result, I have also some real questions and inquiries and some concerns about privacy. I've been concerned for a long time about the casualness with which we confront privacy issues, and particularly I think with young people not quite realizing what it is they're giving away. And some of that's been brought out in the panels, and I think there's some real concerns also that have been manifest by the comments that were made and people who are trying to find a way to provide both security and privacy for all of us. But I would just throw out something that maybe we can think about, and that is in terms of what standards we're going to use, when we talk about our expectation of privacy, that has a very particular meaning for most of us who practice, and particularly in the criminal field, because of the Fourth Amendment. And of course, that has to do with the government's, looking at what expectation of privacy we have when they would desire to intrude upon our property or other kinds of interests that are protected by that right to privacy, so to speak, and what our expectation of privacy is. And I'm wondering if, when we're talking about in the context that we're discussing now, are we setting different standards that could then be used to determine what a citizen's expectation of privacy is under the Fourth Amendment?
So one of your takeaways, if I'm understanding this correctly, that you're reading this, the changes or the impact on privacy that all of the technologies we heard about today, as we try to deal with them, you're in a sense predicting there's likely to be some crossover effect.
I'm not saying
law enforcement. Okay.
But I'm saying, is it a consideration?
Will it?
If you've been willing to give up privacy in so many of these contexts, if you use, for example, Nest and some of the other things that may be sort of intrusions in the home, which is the first place we would look. I'm just saying it raises an interesting question. Could that come back to bite us, essentially?
Yeah, well, I think the concept of the reasonable person is changing, and that applies not only in the Fourth Amendment area, in other areas. I was thinking this morning, for example, standard of care, reasonable care. Is it negligent not to have gas leak monitors in the basement of the buildings that would send a message to Con Ed that there's a gas leak? I mean, maybe now a lawyer will argue, given the current technology, you have to have that kind of a thing. And so I think these things are here, and the concept of the reasonable person will necessarily change. I was here for about half the day. This morning, I did ask my clerks if they had heard of the concept of the Internet of Things. I was not familiar with even the term until I started thinking about this conference. And that doesn't say much, because in the Second Circuit, we are still communicating by fax. And so the fact that the judges are not on top of this doesn't tell us anything. But I was surprised none of my clerks had heard of the concept even. And one amazing thing is that CLIP planned this conference months and months ago, and now the Internet of Things is such a hot topic. So, we should give some credit to CLIP. Some other thoughts running through my head as I was listening. There certainly are, when we look at these things, there are at least three levels of inquiry. One is what's morally right. What do we want to be the right thing in terms of privacy? Another thing is what makes business sense from the marketing point of view. It cuts both ways. It helps a lot, but on the other hand, if it goes wrong, then it could hurt a lot. And then the third level is what's legal. And in terms of what's legal, a lot will change as time goes on. One of the challenges for the courts is keeping up with technology and progress, and we've gone from the Sony Betamax to the DVR to streaming, and the law the courts try to keep up. We keep up by applying the concepts, and then sometimes we have new statutes. Who's Watching Me Now Act. I can't get the right phrase, but there are all these things that are coming up now, and then judges will have the challenge of having to apply these statutes, and then the laws will adopt as well. So there certainly are a lot of things floating around in my head.
It's interesting picking up on the challenge point where your clerks were unfamiliar even with the term. Would certainly indicate that it's going to be extremely difficult for the courts dealing with the cases of first impression, with the first couple cases that will come along into the court system.
And by the way, I asked them to search the phrase Internet of Things, and there were no cases in Westlaw using the phrase. There were no law review articles using the phrase that they could find. So this is certainly ripe for further scholarship. Now, I'm sure there are cases that involve these kinds of issues, and they're just not calling it the Internet of Things.
I'm sure the first time a car that has sensor devices on it crashes into another car will wind up in the courts pretty quickly.
But we could still probably decide the case without using the term Internet of Things as well. But it does have its own acronym, I found out. When looking, when I Googled it, I thought, oh, well, it's already got its own acronym out there, and doesn't seem to be confused with anything else. But you're correct, it's not something that we would ordinarily hear about as terminology in the courtroom. I think we'd be talking about the thing itself. Rather than just the whole notion of Internet of Things.
If the system fails and instead of turning up the heat in your home remotely, it turns it down and then the pipes freeze, that's still a negligence case. It's not going to be called an Internet of Things case, but yet it involves these issues.
It was interesting at the panel this morning. Mark Geisfeld from NYU, who's a tort scholar, talked about the duty of care and how connected devices will be changing the notion of the duty of care. And I wonder, in that context, as you just mentioned, if your pipes freeze because the product didn't work, I wonder how far along it's going to be before society sees that kind of basic functioning as a ordinary duty of care that the reasonable person using a connected device will expect.
Well, I think it's very complicated. First of all, if we can just back up a minute, someone else also during the day mentioned the difficulty of legislation in this area, which probably, it's like a lot of new areas and new technology cries out for legislation. And I wouldn't cry too loudly with respect to Congress because they don't seem to be passing much of anything. And my experience, and Judge Chin can probably agree that in interpreting these statutes, very often we wish they hadn't bothered because there are more questions than answers. But I think we're going to find more and more as a result of either unfair competition statutes and Deceptive Practices Act statutes. And then in California, we have a whole slew of the CLRA, which is the Consumer Legal Remedies Act. I believe that's what it stands for, and a couple of other statutes like that. And I would expect that we would be more likely to find some changes in state law that would help us to the extent necessary. But it is amazing how much tort law, products liability law, other laws that we already have on the books or that are part of common law can be adapted and considered. And I think one of the things also when we talk about, I see it in something we call unauthorized infringement or unauthorized IP, comes up in terms of components that are, upstream, components that are incorporated in products that many times have many components. And there is always an issue, or very often an issue, of a patent infringement by somebody upstream in a component. And what is your liability when you put that component into your finished product? But the same thing also, what if those components have the ability to track or do other things that are not represented to your end user as being a capability or a problem? There are going to be interesting issues with respect to that as well, and what the ultimate liability of the manufacturer who uses those components may have to distributors and so forth downstream in products liability areas. So I think they're just when you take a look at patent law and copyright law and how we've had to modify that in order to come up with resolution of some of the high-tech cases, you realize that maybe it's better to just let the courts try to play around with these concepts than get it mucked up by congressional enactments.
Yeah, in the freezing pipes case, you would return to basic principles of law. What did the contract say? Are there warranties? Were they breached? Causation? What caused the failure in the communication? Who's at fault? And so I think we would be able to sort it out.
Do you think there's anything from what you heard today that is peculiar or particular, perhaps is the better word, in this environment that would be a additional challenge that judges would face? I mean, is there something about the complexity here that you think may be unique?
I think there's always a challenge when we're trying to understand the new technology. I think there are certainly some broad ramifications, including privacy is always hard. There are new concepts of property. Who owns the data? I mean, these are difficult issues. And on some of these things, there may not be an answer in the existing law, and there may be a need for legislation on some of it.
Are you talking about the technology itself and understanding it, or the technology in addition to the law, and whether the law is adequate to embrace the particular technology or
Probably
technological issues?
More the latter, but in the sense of the kinds of uses and the kinds of things that are being made. So if we think the panel on healthcare, where there was a discussion about is it a medical device so that it's going to be regulated by the FDA, or is it not a medical device? And it seems more complex in many ways than the simple example we saw with what looked like a popsicle stick, but if it turned out to be a tongue depressor, it would be treated differently. It's a little easier, I think, to see, is it being advertised as a tongue depressor or not, compared to this environment where it may be a lot murkier. At least, I wonder if your sense is the same.
Well, I think are complicated issues, but it seemed to me that they were able to also present some, good evidence of how you would reach that conclusion. I guess in that case, it's the FDA and what the FDA has to do. And I think those decisions reviewed by the Court of Appeals, so it's your problem. but we also have to interpret some of those statutes as well. But I think, as I understood, the argument is that, or how FDA looks at it is, what are you advertising it for or promising it to be, et cetera, and you use it from that standpoint. If that's the representation, then I think you could interpret it in that way, unless you determine that in fact it's being sold for other purposes or used for other purposes in such a much different way by a larger number of the purchasers that you might want to look at that question and whether it's the appropriate inquiry.
Yeah, I think the legal issues are murkier. There aren't precedents for all of this. There aren't good parallels in the law for all of this. The tracking device and the label is a complicated one. I don't know if there is law on that. You try to think of analogies, and it's hard to come up with.
And what is the obligation of the seller in that case? To notify the customer that once that garment walks out of there, it's being tracked as well.
It can be true. Yeah.
Can be, yes.
Let's see if anyone in the audience has some questions that they'd like to raise. Flora, can we get a mic over here, please?
I don't have the answer to this, so but I keep thinking about it with the clothes with the RFID. Where do you guys feel like the question of harm exists in terms of my privacy being violated? Is that an old-fashioned notion, or do you think that's going to continue to be a question that the courts are asking?
I think it will continue to be a question. I mean, I don't know that there is law on there might be. I'm not sure in other Privacy Act cases whether one can get pain and suffering for the loss of privacy in this kind of situation where you're a consumer and you go in and you buy something and it's tracking you and that bothers you. Can you be compensated for that? I don't know. I don't know if there's precedent for that. In some way, you'd have to go back to tort law. But then the other question is how much? What is it worth? That's always a question. And if you can't really put a number on it, then maybe it's not compensable. I mean, these are some of the thoughts that would flow through my head.
It's a tough question. I mean, there are some areas where you can get de minimis, damages if you can't prove actual or nominal damages. Maybe injunctive relief is the remedy. But you're going to have to show some harm in some respect, whether it's invasion of privacy, qua invasion of privacy, whether that's enough in these kinds of cases. I don't know. But they're certainly in California, and we do have some statutes that I think sort of gets you to that point where you may be able to do it by way of injunctive relief or nominal damages.
Thanks. I was wondering about the concept of level setting with privacy and just the idea of maybe U.S. v. Jones, kind of with the Fourth Amendment and the concurrence. There was sort of Mayor about maybe there's certain types of services where you shouldn't have the right or something like that to give up the right. And I guess the idea is if you go into a store, should the retailer really have the right to track you throughout the store, and should your cable company have the right to track you? And whether there's just some rights that you should affirmatively have to consent before you're being tracked, and where what you think about that.
Well, maybe the first question is there an obligation to give you notice? Because otherwise you would not know. unless something untoward comes or something occurs later down the road, and it could be some length of time. But is there a requirement to give you notice of any kind of tracking or data collection that you would not ordinarily think of in the ordinary course?
I guess unconscionability as well, or contracts of adhesion is kind of like a similar.
Yeah, I mean, there would be a question of what's reasonable. I mean, just instinctively, I think it's reasonable for a store to track you as you're walking around because they could be doing that already with a video camera. So I don't see much difference between that or having someone standing there and watching you and devices in the fluorescent lights picking up your cell phone as you walk by. On the other hand, if it's in the privacy of your home and it's your DVR tracking you while you're in your living room, that doesn't seem reasonable. But then it also depends on the context in which it arises. I don't know that there is law, and that's why there's some legislatures thinking about passing statutes. Otherwise, you have to get back to, is there some kind of common law tort that would pick that up?
And also, what is done with that information or data? Is it retained? And who retains it, who has access to it, and so forth. There's a lot of questions that come about. And I don't know if we have any answers. We're going to have to grapple with it as we do on everything, case by case.
Joe?
I think at times we're also in danger of conflating the technology with the use of information. So Internet of Things, an RFID tag is nothing more than a tag. It identifies something, and it has a range over which it can be read or over which it can broadcast a signal. That's the sum total of what an RFID tag is and does.
Well, except that you don't think that when you leave the store that you are carrying a tracking device.
No, but I'm just saying. But I'm saying the device is there. What the device usually has on it for the purposes of today is on a GS1 tag is that it'll have essentially what's essentially a stock number related to the item that you purchased. And many cases, like for instance, the supermarkets have been using them on some products, and they've found out that it can facilitate recall, but the only way they can actually do a recall is actually if the person has allowed them to associate a purchase with a loyalty card, because then they can associate an identity to the actual thing. Otherwise, it requires you to walk through another reader before you can be. So we're not exactly in the panopticon where just because you're wearing pants, everyone in the world knows where you are because you have those pants on. I think the difference is when you were talking about the phone broadcasts a signal not for the purpose for you to locate me in a store. The phone broadcasts a signal for me to be able to achieve a communication. And while the store can visually watch me in a video camera if they have the proper right to deploy a video camera or have a person watching me, and all those things are observable, and I completely agree with you, I think the phone becomes a slightly different concept because then you're starting to use something for a purpose it was not designed to be used for. And I think that's one of the things we have to start thinking about. I think the notice question becomes critical at this point because, one of the things from a privacy perspective is the avoidance of surprise. What we found is when consumers are asked to actually opt into something, in many cases they opt in large numbers. But what happens is they really get annoyed and you lose brand value in the context of surprise. But I think I'm concerned because at the legislative side in the US and in Europe, what we see is people trying to regulate the technology as opposed to the use of the technology and its information. And that's problematic because those regulations don't track context at all.
Thank you, Joe. Other question? Other question, Mark? I think this will be our last question.
I asked a related question of one of the panels this morning, and I'm wondering if either of you see, given your extensive experience, any likelihood of some sort of evidentiary privilege or other method that would restrict or limit the use of some of these data that are now being collected either with or without notice in either litigation, civil or criminal litigation context or sort of other judicial context.
Thinking about it being obtained by way of discovery
Sure. I
And-
mean, at this point, I mean, the example that came up this morning is if, God forbid, Professor Felton gets into a car accident this evening, we know that he tracks his sleep, and so somebody subpoenas Fitbit to get his sleep tracking records, and they say, oh, well, he was unreasonably tired because he didn't sleep very well. And so the expansive nature of that.
Well, I would assume that that would come up by way of a motion that to with respect to discovery and whether or not discovery would be provided. And there are a lot of questions that would go into, just as you would any expert testimony, for example, the reliability of it and so on and so forth, and whether it really can be used for the purpose that they wish to use it for at trial. And there might be other questions that would be raised as well, but I think the first thing to look at is how reliable is that information? Does it meet the scientific standards that you would want it to meet in order to be admissible? If it's not going to be admissible at trial, then you don't need it. Well, they would say it would lead to admissible evidence, right? But I think you could probably you'd have to deal with that argument as well. But I think there would be a few hoops you could go through rather than just having to disclose it.
Yeah, I mean, I think there are significant ramifications, both civilly and criminally. I remember on the civil side when cell phones first came out, car accidents, and you could figure out that someone was on the phone. And now, of course, there's so much more information that one could get from these devices, whether it's how well a person is sleeping or what. On the criminal side, there could develop additional law. One context, another example that's sort of similar is executing search warrants. When you go in the old days, you'd go through someone's file cabinet and it would take you a few hours and you would take away some relevant things. Now, if you go in and there are 4 computers there and a bunch of hard drives, it would take you weeks to go through it all. So now the law will tolerate making a copy of the whole thing, including non-responsive things, and then the government can take it back to their office, then look at it at a more leisurely pace, in part so that they're not there disrupting your business. And even though some of that stuff clearly is non-responsive, but that's an accommodation that the law is now recognizing. And on some of these other things as well, there will have to be some adjustments.
That's great. Please join me in thanking the panel. Fantastic. And I'll close. I do want to extend some thank yous. First to Ed Felton and Princeton Center on Information Technology Policy for co-sponsoring with us. And an enormous thank you to Cameron Russell, who is standing in the back, our executive director, who's made this possible. To Tom Norton next to him, who's been an invaluable assistant through the process as we put the conference together, and to the Internet Society for streaming us today. So with that, I'll close the conference and invite you all to join us for a little reception now. Thank you.